Hello, friends. Thanks for joining me at Let's Talk About Conflict. Today, I want to give you some information on alternative dispute resolution, or ADR. I'm Lynne Nash, your host, and I am a full-time civil mediator based in Dallas, Texas. And this is stuff I think about on the regular, all day, every day, because this is the world I live in. But we hear this phrase, alternative dispute resolution, thrown around. Or better, you probably have heard the letters ADR. Well, what is ADR and what does it mean? And what is that? And is it one thing? Is it multiple things? I don't know. I actually do know. I'm here to share that with you. Today is about learning what it means when you hear alternative dispute resolution, or ADR. All right. So, detailed information on what it means for ADR. In general, if you just need a off the cuff response, alternative dispute resolution is any process that is outside of court and leads towards the resolution of a conflict. All right, I'm going to say that one more time. Alternative dispute resolution is any process outside of court that leads to a resolution of a conflict. Okay? So why does that matter? Here's why it matters. That's what this whole show's about. So that's a big deal. But also, these are processes that are not necessarily bound by attorneys. You don't necessarily have to have an attorney in all of these processes. And so for anybody listening to this that's not an attorney, this is some great information for you to ask an attorney if you find yourself potentially in a lawsuit, if you can use any of these instead of having to go to court. Attorneys should know what these things mean. Now, for my friends out there who are also JDs, who don't actually know that there are other processes in ADR, this pod is for you too, because I'm going to lay some information on you, which I think is really useful and I think is really helpful to think beyond just a mediation or just an arbitration. All right. So hang with me. Here we go. Generally, we talk about ADR, we talk about it's any process outside of court that leads to resolving conflict. People say ADR and they're going to think one of three things or less: negotiation, mediation, and arbitration. Now, some of you may be going, I have no idea what you're talking about. You're still speaking foreign language. That's okay. I'm going to break it down and give you a little bit more definition. And then in other podcasts, I'll break some of these down even further because they really make a difference to understand. So the U.S. Department of Labor says that the different types of ADR that they see as being ADR include arbitration, mediation, negotiated rulemaking, that's interesting, neutral fact-finding, also interesting, and mini trials. Okay, that's truly in a labor context. Some other parts of business would say none of that, some of this stuff doesn't apply to us. Okay, that's okay. But I want to make sure you hear that because that is one of the ways that the U.S. Department of Labor has broken this into different subsets. And the U.S. Department of Labor was one of the earlier adapters to utilizing things that didn't involve the court system. So here's a really good, funny little tidbit for you. If you type the three little letters ADR into your web browser and you happen to go to ADR.com, you will be taken to American Arbitration Association. ADR.com, American Arbitration Association, which is only one of the processes of ADR. I promise you, it's only one, but they get the website in the domain and they get to, yeah. So what I'm here to help you understand is that is a type of ADR, not the or the one you got to utilize. All right. But it's kind of funny that the arbitration people, they grab that pretty fast, and good for them because I bet they're never going to let it go. I wouldn't. But truly, if you go to ADR.com, it's the home of AAA, and it's only one part of what we're going to talk about. And only one part of what I really want you to understand that alternative dispute resolution is about. So, in my opinion, Okay. Gospel according to Lynne. In my opinion, I think there really are 5 main ADR processes. Okay. Negotiation, settlement conferences, mediation, mini trial, and arbitration. Back to 5. Okay. Negotiation, settlement conference, mediation, mini trial, and arbitration. So put your patience hat on and try and find your education student place and listen to me a little bit longer, because I'm going to take a second and break each one of these down. So, like I said before, there will be additional podcasts that will go into great detail about fully how these different processes work. Some of them that are a little bit more mechanical and there's lots of different rules around them. But today I want to give you kind of the overview of alternative dispute resolution. We'll break it down further in other episodes. Okay. Number 1, negotiation. Negotiation is simply defined as the process of parties bargaining in an attempt to reach an agreement. Okay. They bargain in an attempt to reach an agreement. It's not a guarantee that they'll reach an agreement, but they're going back and forth to try and get to something that they all can live with and move on. So a lot of times this is about bargaining. You negotiate, you bargain the terms of a contract prior to entering into it. So salespeople, you do this all day long. You have to figure out and bargain to give this and take that to find the sweet spot until you can move on. I've been known to say that every good contract has enough knives on one side and enough knives on the other side that they think they can stab each other later, and so they can sign the dotted line. That's a lawyer perspective. That's probably not what salespeople want to say, but at the end of the day, you got to give and take enough to get the deal done, and that's negotiation. If you want to think about it a little further, think about when you were a kid, or the fact that you have kids that maybe you have to do this with, and you want to talk about curfew, right? Oh, hey, you're going out to do da da da. You need to be home by 9. Well, I really think it's going to be later than that. I'm be with so and so, and I don't think I can get back here before 11. Okay, well, maybe we can say 10. Well, I'm not sure I can make 10. Can I have 10:30? That's a negotiation. That is a full-on negotiation. And so you probably negotiate things in your life without even realize that's what it's called. It's not something that should feel unfamiliar to you. But a one-time offer is given, another offer is made, a counter, maybe an acceptance is somewhere in the middle. That's negotiation. We're talking about kids and curfews, and do you negotiate with your kids as a parent? I don't know. Somebody once said to me that they refuse to negotiate with their children because, just like the good old United States of America, they do not negotiate with terrorists. Call their own kids terrorists. I'm not saying I don't understand. I'm just saying it's kind of funny. So negotiation, bargaining in an attempt to reach an agreement. Not a guarantee, but bargaining towards a goal. Settlement conferences. This is number 2 out of 5. Settlement conferences. These are not as well known, okay? But settlement conferences are used for the primary purpose of assisting parties in resolving disputes, and for a secondary purpose of narrowing the issues and preparing for a potential lawsuit or even a hearing within open litigation. Now, the reason you may not have heard of settlement conferences before, or you didn't know there's an actual term and a name for it, is because most settlement conferences are held between attorneys. Sometimes the clients aren't even present. Sometimes the clients give the attorneys some boundaries, and the attorneys go into settlement talks to see what they can get done. I know plenty of attorneys who would say, I've never been to a settlement conference. And I'm like, yeah, just because it wasn't a formal proceeding that you put a time on the calendar and this, that, and the other. When you pick up the phone as an attorney and call the other attorney and you're trying to work it out to see if you can get the deal done, that's a settlement conference. Okay. Hashing out the legal points and looking for a way to compromise into a deal that the attorney's client can live with. That's what happens in a settlement conference. Now, I am a full-time civil mediator in the state of Texas, and I believe you cannot do mediation in 2-hour increments. I know that makes me unpopular with a lot of people, but I don't think so. And I have a lot of education and research that says, yeah, I don't think so. I do very firmly believe that settlement conferences are 2-hour increments. That's a great amount of time for have the attorneys come in and hash out the legal points and see if they can get a settlement. The problem I see in my neck of the woods is that I've got courts ordering mediation in some cases that maybe could be done with a settlement conference, and maybe you do have a neutral settlement conference can have a neutral involved to help between, but it's the attorneys doing all of the negotiating, and the clients are really in the back seat at that point. So I think a 2-hour concept is a settlement conference. 4 hours and more would be more of a mediation. We're going to get to that in just a second. But settlement conferences are very useful. And it's kind of a shame, at least in my state, that courts don't order settlement conferences as well as mediations. I mean, there's all these wonderful rules about you need to consult with opposing counsel before you bring things before the court. Sometimes that happens, sometimes that doesn't. Or it's a one blasted off email and magically you consulted. You didn't. The courts are not pleased with that behavior. But settlement conferences are useful and they can really move the needle ahead, because even if you don't clear up everything and make the case go away, you may narrow the constraints of the case so that you make the actual litigation far more intentional and cost effective for your client. So that's an interesting way to look at it if you need to understand the difference and why you would or wouldn't want to ask for a settlement conference between the parties and bring in a neutral like myself or not over a mediation itself. Now, said mediation about 100 times. Let's get down to it. Without a doubt, this is my favorite form of ADR. I have a degree, my master's is in conflict resolution and restoration, and it was primarily focused around the process of mediation. So what is this thing? I keep talking about mediation. What is this thing? In simple terms, mediation is a guided negotiation facilitated by an impartial third-party neutral who is trained in active listening and negotiation strategies. That's a lot of words, I know. This neutral, the mediator, listens to both parties, asks questions to help facilitate understanding and dialogue, and works with all the parties involved towards settling their differences and reaching an agreement. Now, why is it about settling their differences and reaching agreement versus settling the case? Because a lot of things come to us as mediators without even being a court case yet. We call it pre-suit mediation if you're in the legal world. And they're kind of fantastic. I have to say, as the mediator, the attorneys that call me up and say, hey, can you mediate this it's pre-suit, we think we can sort it out, we just need your help. That is, man, I get up and jump out of bed on those days because I'm really going to get to dive in and help somebody. The interesting thing about mediation as a process is that it can be done pre-suit, like I was just talking about, but it can also be done in early stages of litigation and very late stages of litigation, kind of even on the eve of a trial. Now, I've been known to say in a mediation that I am the cheapest thing they will do in their litigation process, i.e., would they pay for me to come in and be their mediator and their attorney's time during the mediation? That is the cheapest thing they can do to try and stop the bleeding or litigation, but get to a place of understanding and stop spending money on trying to win and get the deal done, right? Trying to figure out how to get the thing done. I will say, in my own opinion, I think mediation isn't necessary. This is a really unpopular thing, so let me just get it out of the way. There are plenty of lawyers who will say a mediator that doesn't get the settlement on day of mediation is worthless, and they want to know what your settlement records are and this, that, and the other. I want to tell you, I don't know a mediator who doesn't want to get it settled. I mean, that is what we showed up to help with as the neutral. But I have never had a mediation finish, whether they reached a settlement and we signed papers or not, that the people didn't walk out understanding why they were making the decisions they were making. And that alone is a great process for these individuals in understanding why they're making their choices. So, it's a give and take. We will have a whole podcast and probably many on mediation, so I won't spend too much more time on this. But it is a really great way to help people. That being that third party neutral, I have no allegiance to anybody but the deal. I believe my job is to think about time and liability and risk and money. And that's it. The rest of it's the attorney's jobs. I love what I do. So you'll hear me rant and rave about more of that later. So moving on from mediation, the fourth process of ADR that I want to talk to you about today is mini trials. A lot of people don't even know what these are. Mini trials are private and they're consensual. So the attorneys for each party make a brief presentation as if the case is at trial before a neutral. The presentations are made, and this neutral advisor evaluator will give them an assessment as to the merits of the arguments. Now, what does all that mean? It means that most of the time, many trials are brought before a former judge. And there's a really good reason for that. I don't know that you have to, but a former judge, because it's about how is this going to play out in a court of law, not necessarily how is this going to play out in public opinion. And it is a much more cost-effective way to assess whether the litigation needs to stop and they need to work on trying to get a settlement, or their strategy going into their long-term trial maybe is or isn't as strong as they thought it was. This is becoming more used. I think it's really a great tool. This is not cheap. Okay. None of these things are really cheap, except negotiation, because you can do a lot of that yourself. But they're really meant to assist litigators in determining a good strategy for trial, and or to assess if this case is better in settlement, rather than going ahead with the trial based on this neutral evaluator that these two parties have agreed to have listened to the case. They can be done before litigation, which is probably not going to happen because they'd be formulating in the dark. But they're definitely done in concert with active litigation and to determine what the value of the case might actually be or not be. I think it's a great opportunity for people to assess the value of their case before spending a whole lot of money. And maybe you should do it before you go to mediation, even, right? Some of these things are interchangeable and some of these things can be used hand in glove, but mini trials is something I wish more people thought about. So last but never least, arbitration, number 5. And as far as ADR.com goes, it's number 1. Arbitration is a process in which a dispute is submitted by agreement or contractual clause, making it mandatory to one or more arbitrators who make a binding decision on the dispute. Okay. That's a lot of, okay. Binding decision on the dispute, and it is not in a court of law. Okay. You are guaranteed right now, anybody listening to this is bound by contractual clauses that say if there's a dispute, this has to be taken to arbitration, and it has to be an arbitrator in X state and and these qualifications. And it's fascinating how these clauses have made their way into almost every contract that's out there. Your cell phone has one. Your everything has one. It's fascinating. You might want to pay attention to them. Not that you could do anything about it, but you might want to pay attention to them. Many attorneys treat arbitration as private trial. Many trials are private trial. This is a usually mandatory system that is through a contractual clause, and the rules of evidence and civil procedure are not even the same as those in either a federal or state court. They can be specified by the terms of the arbitration clause or the organization that was identified within the arbitration clause, such as the AAA, American Arbitration Association, or many others. Wait, we're back to AAA, American Arbitration Association, and ADR.com, right? Remember that part? Arbitration was once held out as being a faster and more inexpensive way to settle disputes, but I would be quick to argue that's just not true anymore. So there's some pendulum swings going on right now in the world of ADR, and we're going to see how it all shakes out. Talk about it a little bit more on another podcast. So with that, I take a deep breath and say, alternative dispute resolution means many, many different processes that are out there. And again, the 5 that I want this audience to make sure they're aware of are negotiation, settlement conferences, mediation, mini trials, and arbitration. I will break these down a little bit further as we go along together. But without some of this base understanding and the acronyms that get thrown around this world, I'm not sure it's going to help you if I don't make sure you have a little bit of a definition moving forward. So with that, your host and guide, Lynne Nash, I will leave you to ruminate. There will be people who disagree with me on this. I am 100% okay with that. If you disagree with me, give me some feedback. If you think there are some other processes that I didn't talk about should be in the top 5, let me know. I don't want to say this as if people have no idea what's going on, but I want to make sure we're all on the same page about what the definition is before we get too far down the road. So I hope you come back and join us again. I hope I didn't bore you to death. But this is what I do, what I think about, and why I am doing the podcast. Let's talk about conflict, because every bit of what we've talked about today are ways to help resolve conflict. Just 5 very formulaic ways to take somebody through it and help them get to the other side and find agreement, or at least an end point where everybody's got enough to get on with their lives, right? Thanks for being with me and for giving me some of your time. And I will hopefully see you on another episode.